Before we begin, I would like to acknowledge the traditional owners of lands that we are broadcasting from today. I'm here on Gadigal land. The Gadigal people, I pay my respects to the Gadigal people of the Eora Nation. And we also acknowledge that Aboriginal people are the first educators on this land. We're doing a legal education webinar, and we like to acknowledge that. So thanks again for joining us here today. A quick overview of what we'll be doing today. So we'll be giving a brief rundown on what is traffic law, what we mean when we talk about that. Also, we're going to be talking about options if you dispute a fine, and also about electing to take traffic matters to court and options for dealing with fines. So we're talking today about the law in New South Wales. I know we had some questions in advance of the webinar about are the laws different in Victoria, for example. So these laws can be different in other states and territories. So today we're talking about the law in New South Wales. And yeah, we do know people join us from those border areas, so just please keep that in mind. This webinar is for the public, but we also welcome our colleagues from the community sector, the legal assistance sector. We know there are some interpreters joining today. So we hope that everyone learns something new and interesting today, and something that you can take back to your friends, families, or the people you support. So I'm going to hand over to our wonderful panel to introduce themselves. My name is Natalie. I'm the acting solicitor in charge of the Community Legal Education branch here at Legal Aid New South Wales. I'm facilitating this discussion today, and I will now ask our experts to introduce themselves and a little bit about their work or their service. So, Your Honour, Deputy Chief Magistrate of New South Wales, would you like to go first?
Thanks, Natalie. Welcome, everyone. I too acknowledge the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respect to their elders past, present and emerging. At least that's where I'm patched in from, at the Downing Centre, one of the busiest places on earth in my view. I often liken what happens in the local court to drinking from a fire hydrant. There's so many matters that come before us. We sit in a number of locations across the state. We have about 150 magistrates who service all these local courts. I have the added responsibility, together with my co-deputy, Deputy Chief Magistrate Sharon Freund, of looking after a lot of the operational aspects and administrative aspects of what happens in the local court. I've been in this role for the last 18 months or so, but I've been a magistrate since about 2010. So I'll do my best to answer any questions you may have and to participate in the discussion in what I can see is a very busy and packed list of participants. Welcome.
Thank you. Tegan, would you like to introduce yourself and your work?
Good afternoon, everyone. My name is Tegan Naidu. I work at Marrickville Legal Centre in the Criminal Law Service. So Marrickville Legal Centre is a community legal centre. We provide free legal advice to people who fall within our catchment area, and my service provides advice in relation to crime and traffic and ABOs. And so today, what I'll be focusing on is the type of advice that I generally provide to people, the common traffic questions that we get, and hopefully clearing up some misconceptions about traffic law.
Perfect. Thanks, Tegan. Kirsty.
Yes, good afternoon, everyone. My name is Kirsty Harrison. I'm from the Work and Development Order Service at Legal Aid New South Wales. I'm joining today's webinar from Dark and Young Country, and I'd also like to acknowledge and pay my respects to elders past, present and emerging. The Work and Development Order Service at Legal Aid sits within the Civil Law Division, and we're a statewide service. We have teams in a number of legal aid offices across New South Wales, and we cover the entire state. We provide quite a lot of support, advice, and training to work and development order sponsors. But a lot of our work is also assisting individuals that have large fines debt or have complicated fines matters. And our paralegals run a WDO placement service. So they help people who have fines find a suitable WDO sponsor. So that's us.
Thanks, Kirsty. And if you haven't heard of WDOs, you will by the end of this webinar. So I'm going to launch a quick poll first to get us started. So hopefully you can see that. It's a bit of a funny one, but what do a home and away star, a former New South Wales judge, and an Instagram influencer have in common? They all drive a Jeep Grand Cherokee. They are all regulars at their local library, or they have all had driving fines and lost demerit points in New South Wales. So I'll give you a quick second to answer that. And it looks like it's a very definitive answer. I'm just going to end that now and share the results with you. So as you can see, most people have guessed that they've all had driving fines and lost demerit points in New South Wales. We don't know what type of car they all drive. And I'm sure it was one of the libraries who said they're all regulars at their local library, which they probably are. That's great. So the point of this is just that how common driving offences are. This topic is really relevant to all of us, and fines can impact anyone with a driver's license, among other things. So yes, the point of that is just how common this topic is and how relevant and worthwhile it is hearing about it. So thanks everyone for that. Okay. So we're going to kick off our panel discussion today with Tegan. So can you please give us a quick overview of what we mean when we say traffic law or driving offences? What are we talking about, and what are some common things you advise people about in your work?
Yeah, absolutely. So when we talk about traffic law and traffic offences, we're talking about a whole range of things. We're talking about when people receive penalty notices or fines in relation to particular road rules or breaching road rules. We're talking about different license holders of different vehicles and demerit point limits that apply to different license classes, and potential accrual of demerit points and how that affects loss of license. We're talking about if people are charged by police with traffic offences that end up in court and how that court process works. So there's a whole range of things and a whole lot of different effects that it can have on people. Common questions or cases that people approach us with at Marrickville Legal Centre are where someone has received a penalty notice and they're wanting to know what their options are, what they can do about that penalty notice, how to manage a loss of license and fines. Yeah, they're the main things that we cover.
Great, thank you. Yeah, you mentioned going to court, and we will be covering that in detail today. But I guess before it gets to that stage, Kirsty, I might just ask you, so if someone does get a fine for a traffic offence, but they think that's unfair, they dispute that they did that thing, they dispute their fine, what are their options, I guess, before that stage of court?
Yeah, look, there are a number of different options. So I guess in scenarios to think about. So when we're talking about traffic matters in a situation where, for example, someone wasn't the driver at the time of the offence, then there is a process where you can nominate the person who's responsible. So you can do that on the Revenue New South Wales website, or you can do it in writing by providing a stat dec or a statutory declaration. And usually you have to provide certain information like the full name, address, date of birth of the person you say is responsible. So that's for driver nomination. If we're talking about someone who disputes that they they dispute the fine, then they should think about an internal review. So an internal review is where you ask Revenue to conduct a review. There are certain guidelines that they have to apply when they're making that decision. And you can do this at any time. So even if an overdue fine has been issued, you can still make an application for an internal review. There is only one exception, and that's if you've paid the fine in full before you receive the fine reminder notice. If you did that, then you have only 60 days to ask for a review. You can ask for a review if you think a mistake's been made, or you want Revenue to consider special circumstances around the offence. Revenue will look at your personal situation and any circumstances that might have resulted in you receiving the fine. One thing that comes up quite a bit is someone, for example, who has there are some situations where Revenue will caution someone who has a good driving record. So if you have had your driver's license for more than 10 years and you have a clean driving record, then you might be eligible for a caution for some offences. So if these are not serious offences, so cautions don't apply for things like any school zone offences or any offences that were committed in a school zone, mobile phone offences, red light offences, and speeding offences where it's more than 20 kilometres an hour. But there are some low-level offences where if you apply for an internal review, then Revenue will give you a caution, which means that you don't need to pay the fine and any demerit points that attach to that won't apply. But if you're asking more broadly for Revenue to consider some circumstances, you can submit your review online. The fine is on hold while they make a decision, so no action's taken during that time. And you explain to Revenue the circumstances. So why you're seeking the review, and if you have any documents or evidence that you would like them to consider, you would attach that to your claim. So for example, if you say my car was stolen and that wasn't me that committed the offence, then you might provide a copy of the event number or of a police report. If it's a medical emergency and you're asking them to exercise their discretion, then maybe some hospital admission paperwork or something like that. So then Revenue will make a decision. They'll tell you the outcome of their decision. So it could either be fine to stand. So that means that the fine's issued correctly and you need to deal with your fine. They might issue a caution, so exercise their discretion, apply the guidelines, and they say you are responsible, but because of your circumstances, we're giving you leniency and you don't have to pay the fine and any demerit points aren't attached, but it will still show up on your traffic record that you've had a caution, or it could be cancelled. So that could mean that the issuing authority asked that it be withdrawn. I guess, yeah, the key message is if you do dispute your fine, before you make any decision around court election, you should consider the internal review option first.
Great, thanks, Kirsty. And we did have a question someone put in before the webinar asking if there are costs involved in disputing an infringement notice.
Yeah, so through this internal review process, no, there are no costs involved.
Okay. Right, but there might be some costs involved to court.
Yes,
to court, which we'll talk about in a minute. Great. Now I might ask, Your Honour, are there types of driving offences which need to go straight to court, which when people don't get that penalty notice, they might get a court attendance notice instead?
With respect to discretion, police officers have some discretion to issue an infringement notice, for example, for low-range drink driving, something they were not able to do previously. But as the offences get more serious, they tend to issue a court attendance notice, so that is a charge. Those matters come to court, and in the ordinary course, when they get to court, we ask you whether you are pleading guilty or not guilty. I usually make it really clear when someone is representing themselves, and I say you have two options. Option one, you can plead guilty with an explanation, and I will do my best to try and finalise your matter now. You'll walk out of here and you and I will never see each other again. Option two, you can plead not guilty. That means you will need to come back in a few months' time on the allocated hearing date. On that occasion, the police or the prosecuting authority will call the witnesses on whom they intend to rely to prove the case against you. They will give some evidence. You'll be able to cross-examine them. You may give evidence, although you don't have to. And then at the end of that process, I will decide whether you are guilty or not guilty. Most of the time when you say it that way, when you explain it that way, people understand what their options are once they have attended court.
Thanks. And Tegan, as lawyers, we probably say people should seek legal advice before going to court, even if they do plan to represent themselves.
Absolutely, yeah. There are definitely some considerations that people need to take into account before they elect to go to court, if that is the option that they have, or even if they've been charged by police and they have to go to court, they should still seek some legal advice to think about potential consequences that can flow from different decisions they make through the court process.
Right. And Your Honour, from your experience, can you please talk us through why people might elect to go to court for a traffic matter, and importantly, what people should think about before they do that?
When people court elect, they usually want to come to court to have their say. Most of the time, they don't really want to plead not guilty and have a fully defended hearing. Most of the time, they want to plead guilty and they want their circumstances taken into account by a magistrate. That will involve mitigating factors, that is, things that they may have done that might lead me to believe that they have changed their ways. For example, a traffic offender intervention program, they might have done a drug and alcohol program. Their circumstances, their personal circumstances may have changed. They no longer own a car. There's a whole range of different circumstances which they may want a magistrate to take into account before passing sentence.
Right. And is that, Tegan or Kirsty, that's advice you give as well? People should be cautious before they elect to go to court?
Absolutely.
Yeah.
The same page.
Yeah. Right.
Yeah, I think it's really important that people, I mean, I know that this is something that you've said, Nat, but that people get legal advice before they court elect, because there are a number of ways that fines can be dealt with without, you know, for people that, say, for example, in the example that Isona gave, people that might, you know, want their circumstances taken into account, they might not be able to afford a fine. So, you know, they are seeking a court election because they want that to be reduced. But yeah, there are quite significant problems with court election.
And at the moment, you can't, once you've ticked that box or gone on the website and elected to go to court, you can't reverse that or unelect. Is that correct?
Correct. At the moment, I've put some submissions into the Attorney General with respect to a proposal that one day you might be able to unelect, but at the moment, once you've elected, it has to be judicially determined. That might be judicially determined by way of a plea of guilty and sentence, or it might be judicially determined by way of a plea of not guilty, a full hearing, and then if you're found guilty, sentenced.
Yeah.
I suppose the other thing that people need to remember is that once you do elect to go to court on a, for example, $300 fine, usually those types of regulatory offences under the Road Transport Act carry a maximum penalty of $2,200. And so if you are found guilty after you have had a defended hearing, or even after you've pleaded guilty in court, it doesn't necessarily mean that you will get the same fine you would otherwise have received had you paid the infringement notice. Once you come to court for a standard fine-only offence under the Road Transport Act, the usual maximum penalty is $2,200. So you may find that the court will impose a fine of $800, whereas originally it was an infringement notice amount of $300.
Yeah, so very good reason to get that legal advice first before you jump in and elect to go to court. We've had a question which I might ask now from our audience. If you plead not guilty and unfortunately lose the case, is there an option to ask for it not to be on your traffic or criminal record?
Yeah, just as you can when you plead guilty with an explanation. What that question is directed to is, can you ask the magistrate to make an order not entering a conviction and placing you on a conditional release order for a period of time without conviction? That's one of the options. The other option, of course, is a non-conviction outright under section 10(1)(a). So you can ask for that, but sometimes it's much more difficult to persuade a magistrate to lean that way once you have had a fully defended hearing and you've been found guilty. That's because the system is geared a certain way. Fines are pitched at a certain level to encourage people to pay them, that is, infringement notices. If they choose to go to court and they plead guilty at the earliest opportunity, ordinarily they are entitled to a discount on the sentence they would otherwise have received. But if someone court elects, has a matter heard in court, pleads not guilty, and then is found guilty after a fully defended hearing that has taken numerous mentions in court, half a day, witnesses for the prosecution, witnesses for the defence, prosecutors, court staff, a magistrate, the cost to the system is much more. And so it's a lot more difficult to justify at that juncture a non-conviction outcome.
Another thing we hear that people often don't understand is that most traffic offences are what we call strict liability offences. Your Honour, can you just explain a bit more what we mean by that?
Well, without going back to law school, strict liability offences are offences which don't require the prosecution to prove mens rea, that is, intention, in respect of at least one element of the actus reus, that is the guilty act. Absolute liability offences are ones which don't require the proof of the intention element and can be satisfied by proof of the act alone. The difference between the two is that with strict liability offences, there is an available defence of having an honest and reasonable mistake, whereas absolute liability offences don't have that defence at all available to a defendant. Of course, absolute liability offences are pretty rare, but strict liability offences are ones which governments use to regulate very administrative style offending, road transport, health, environmental offences, things like that.
So as an example, if you drive through a stop sign, you can't say, oh, I didn't know it was a stop sign, or I didn't know what that meant.
Yeah.
Is that what you mean? Yeah.
That's a good example.
Okay. All right. So Tegan, we've mentioned about demerit points and fines, and I think something you hear quite often is people saying, I don't mind paying the fine, I just don't want to lose the points. So can you explain what advice you give if someone's in that situation and how that works?
Yeah, so I think it's important that people understand they're two separate processes. The court doesn't have any direct power over demerit points. So if someone's priority in dealing with a traffic offence is to keep their licence, then the focus needs to be on what are their options in relation to demerits, rather than risking, by court electing the penalty notice, risking the potential of, as His Honour mentioned, an increase of fine and also a risk of a conviction being recorded against them. Instead of that, what we often would advise, obviously every case is different, but often we would advise that instead of going down that path, if they're happy to pay the fine, to do that, then what will usually happen is they'll receive a notice of suspension in the mail from Transport, and that notice of suspension will indicate that that person has accrued the relevant demerit point limit for their license that they hold, and that they're due to, their license is due to be suspended starting on a particular date. And at that point that they've received that letter, that person then has the option to lodge a license appeal with the local court. By doing that, and as long as they do that before the date that their suspension is due to start, that allows the court, or gives that person the option to ask the court to either completely remove or reduce their suspension period. This is a lot more of a discrete power that the court has. Doesn't have any power to convict that person or impose a fine when they're just purely looking at a license appeal. It's a much less risky option, and in this particular scenario, which we do encounter quite a bit, it's more relevant to that person's priorities in this particular case to be able to focus on potentially keeping their license or at least reducing the suspension period.
And if someone has received a notice in the mail where they've got a fine for $300 and 2 demerit points lost, can they say, oh, can I just pay the $300 but not lose the 2 demerit points? Is that possible?
Unfortunately not. They flow together. So once the fine is paid, that will alert Transport that the demerit points are to be applied to that person's license. And if those 2 points put that person over their demerit point limit, then unfortunately that's what will flow from that, the notice of suspension.
And then there's the option of what you just spoke about. Yeah, thanks for that. We had a question in advance of the webinar about some changes that potentially the new government were thinking about doing for returning demerit points after 12 months. Look, what we've found is it doesn't look like there's been any change to the laws around demerit points since the new government has started, but it's only been a couple of months, so it's really early days. So at the moment, the laws around demerit points are as they were. So we're going to go to our case study now, and we might have touched on some of those issues. Okay, so I'll read out the case study and then we'll talk about what the options are. So Tom received a fine in the mail for $469 and 3 demerit points for driving through a red light. He says it was a confusing intersection and he thought the green light he saw was for him. He stopped when he realised and reversed back behind the line when he realised the mistake, and he didn't proceed the whole way through the intersection. But nevertheless, that camera went off and he got the fine in the mail. So what are Tom's options? And the little writing along the bottom there is just that this case study was inspired by a true story that happened in New South Wales. So I'll just ask each of the panelists to talk about, I guess, how they would advise Tom and also what might happen in this case. So Tegan, I guess first going to you, what would be the type of advice from a lawyer if Tom went to see you?
Yeah, I think one of the things that a lot of people are not aware of is how these cameras operate in terms of how they detect red light offences. And I'd be explaining that in order for the red light camera to be triggered, there needs to be 2 things that happen. Firstly, that the light turns red, and then secondly, that a vehicle crosses the stop sign. So the difficulty that Tom faces is that if he believes that, you know, he did go across the stop line, then what His Honour was talking about in relation to the liability of the offence, it sounds like unfortunately he may be guilty of this. Even though he mentions that it was a confusing intersection, unfortunately the intent and his, you know, best attempts to reverse back unfortunately don't allow any particular legal defence for this. However, he could explore, as Kirsty was mentioning earlier, if he at first instance doesn't wish to pay the fine, he could explore an internal review as a first point of call.
Okay. And I'm just going to pop back to a question we had earlier, which is around, so if Tom wanted to get photos of this red light, or like a speed camera as well, are there costs involved if he wanted to get those photographs?
No, he can get them online, either via the Revenue website, or I believe you can also access them on Service New South Wales.
Okay, great.
And no
Thanks.
cost.
So Kirsty, while you're on, did you want to talk more about how you would advise Tom about his options?
Yeah, I mean, I think as Tegan said, if, you know, he had particular circumstances, maybe he had some things going on, maybe, you know, he might want to consider an internal review. But if it was the case, for example, where he says, okay, well, now I've had advice, I accept that I crossed the line, and I'm responsible, but I need some help to pay the fine. I don't have $469 handy within the next 28 days, then there are a number of options that he has. I think there might be a slide.
We're going to, maybe we'll, yeah, okay, we'll talk about that now.
Did you want to
Sounds
talk about
good.
it now, or did you?
Yeah.
Yeah.
Let's do it now.
So he could pay.
Actually, sorry, I'm gonna
Yep.
I'm gonna pause you there.
Sure.
And we're going to do another poll, because while we're on the topic of fines, we just want to hear what people's knowledge is currently. So let me, I'm just going to try and get to, no, I can't find my second poll at the moment. Oh, wait, yes, I can. Sorry, my fault. Okay, I'm just going to launch this. Not letting me. Sorry, technology. No, can't launch the poll. Sorry about that. Let's just go on to our slide. I was going to ask the group, which of these options have you heard of? So just keep that in mind. If there's some of those that are new to you, this is what Kirsty's going to be talking about now. So over to you.
I can see the polls. Oh no, it's disappeared. The poll went up then. So,
oh wait, there you go. Now it's working. I think it was just some slow thing. So just really quickly, if you'd like to participate in the poll, please do. So which of these options for fines have you heard of? So pay the fine by instalments, request a review, elect to dispute the fine in court, work and development order, or apply for a write-off. So you can click all the ones you have heard of. So we've got, I'll just end that now, just so we can move on, although, all right, I'm just going to end that now and share the results. So as we can see, most people have heard of instalments, review, because we've been talking about that just now, and court, and only 50% of people have heard of a work and development order, and only 19% have heard of a write-off. So that's great that we can talk to people about those today. So thanks for that. Sorry for the technology glitch. Thanks, Kirsty. So yes, Tom, let's say in this case study, and we'll talk a bit about going to court later, but let's say he decides, okay, it is, I did go through the red light, I do have to pay the fine. What are his options?
Yep, so he can pay it by the due date on the notice, which is 28 days after it's issued. If he wants the option to pay by instalments, so he can't afford it within that 28 days, but you know, he's able to pay it in smaller instalments, he can do that. If it's with penalty notice, you can make that instalment plan online. You can do that online, or you can ring Revenue and set that up. We've spoken about request a review, so I'll leave that, and we'll talk about the court election in a moment. But I guess the other two options for payment are around for people who, say, for example, are in severe financial hardship, who might have a disability, might not be able to participate in a work and development order, then we can do what we call, we can make a write-off application. So that's where we ask Revenue, we make an application, provide a whole bunch of information about a person's financial circumstances and ask Revenue to write off the debt. They don't, you know, there are certain criteria that are taken into account by Revenue, and not everyone has, you know, the option to make that application. Well, they can make that application, but they're not always successful unless someone can demonstrate that they are in severe financial hardship. An option that I guess only half of you knew about is work and development orders. So that's where eligible people can participate in activities, treatment programs, volunteer work, educational programs to work off their fines debt. So there, you do that by engaging with a work and development order sponsor. So there are over 2,500 sponsors across New South Wales. So that includes, you know, a bunch of NGOs, it can include psychologists. We have a whole different range of sponsors, and people who are eligible for participation in the scheme can engage with them to work off their fines debt. Different activities have different cutout rates. So, and you can find out more information about that on the Legal Aid website. In terms of eligibility, it's people who are in financial hardship that are eligible, people that have a mental illness or a cognitive impairment, people that might be experiencing an addiction to drug or alcohol, and also young people are eligible for participation in the WDO scheme. So anyone who's under the age of 18 is able to participate.
Great, thanks, Kirsty. We might just go back to the case study and hear from Your Honour, if Tom was to take this matter to court, what would the magistrate take into account? And I'll just point out that in the real life story of this case study, he did, I think, ask for an internal review at Revenue and was told that the fine would stand. So now what are his next steps? What are the options in court?
So when he gets to court, he needs to decide whether he pleads guilty or not guilty. Most of the time, as I said earlier, people want to have their say. They want their personal circumstances taken into account. So Tom might, for example, plead guilty and tell me a little bit about some of the things he was labouring under when he went through the red light that day. He may have been distracted, he may have had some illness, he may have been labouring under some personal circumstances, there may have been some family issues. Whatever it is that he will tell me, I will take into account and I will determine whether he ought to be convicted and fined, or whether he ought to be dealt with by way of a non-conviction with or without a good behaviour bond for a period of time. It might be 6 months, it might be 12 months. One thing, as Tegan said earlier, I cannot do is divorce the fine I might impose from the demerit points. And some people, as you said earlier, say, well, look, I don't mind paying the fine. I might need a little more time to pay the fine, but I can't afford to lose the points. If I do, I'm going to lose my job. And here's a copy of my contract of employment that says I must, for so long as I am employed here, have a Class C driver's license. And if you convict me and I lose these points because I'm already on 2 points, I'm going to lose my job. So these are some of the things I might take into account and determine whether I should convict Tom and fine him or take some other course.
And again, in the true version of this case study, I believe that our Tom pleaded guilty in writing to court, so he didn't have to turn up to court. Can you please explain a little bit more about that option?
So there are two options. You can lodge a written plea of guilty and ask for your matter to be dealt with in your absence, and you might attach to that written plea of guilty, it's a form, some of your circumstances. Alternatively, you can turn up to court and you can speak to your circumstances. A lot of the time, people don't want to take a day off work and lose the wage that they would have received that day, so they send in a written plea of guilty with their explanation and their circumstances. And I will deal with that matter in the same way I would deal with any other matter. That is, I would read the facts, read the circumstances, consider the views of both the prosecution and the defendant, and I would give some very short reasons for my decision before imposing whatever penalty I thought was appropriate. Just because you send in a written plea of guilty, though, does not mean that it will result in a conviction and a loss of points. On the contrary, there are people that have sent in a written plea of guilty whom I have dealt with by way of a non-conviction as well, provided their circumstances and their explanation is equally compelling.
And I believe that that was the outcome in the real Tom's case, so he was lucky. Now, Tegan, can you just answer if this situation would be any different if Tom was a young person, if he was under 18, maybe on his P plates, or would this be any different?
I think two things for Tom to bear in mind would be that even if he's under 18, this is still a matter that would be dealt with in the local court. So ordinarily the local court and the children's court deal with, children's court for under 18, local court for 18 and older. But when it comes to traffic matters, those generally get sent to the local court. That's just something for him to be aware of. And then I guess the second thing for him to be aware of, because he's on his P plates, this isn't something that the court will necessarily, or the court will deal with, but it's something to be aware of. Being on his P plates means he has a different demerit point limit to people who have their full license. So these 3 demerit points may very well get him close to his demerit point limit, and that's something for him to consider, depending on if he has other demerit points currently on his traffic record, and that this may take him over to receiving a notice of suspension.
Just to add to that, if you are on a P1 driver license, you're entitled to incur 4 demerit points. If you are on a P2 driver license, you're entitled to incur 7 demerit points. If you are on an unrestricted Class C driver license, you're entitled to incur 13 demerit points. And take it from me, I've seen the whole gamut of loss of demerit points, including people who have lost 60 demerit points, 80 demerit points in the last 3 years. And that's the relation back period that we always look at. That's the relation back period to which the RMS turns its mind, because that's how long it takes for you to get your points back from the date on which you lost points for a particular offence.
Right, thank you. We've just had a question about if somebody pleads guilty or is found guilty of one of these offences, does it show up on I think it's asking about, does it show up on a criminal record, and can that affect you when you're applying for certain jobs?
It does show up, and it will say, for example, what the offence description was and what the outcome was. It'll also appear on your traffic record. Now, the answer to the second part of that question as to whether you need to disclose it depends on what question you are being asked by the authority. If it's an employer, if it's the RMS, if it's an insurer, they might ask the question, have you ever been convicted of a driving offence in the last 5 years? If you were convicted and you were fined, then the answer to that question must be yes. If, however, your matter went through court, you were not convicted, that is, the conviction was not recorded, and you were dealt with by way of non-conviction outright or a non-conviction conditional release order, then the answer to the question is no, I haven't been convicted. If the question, though, is have you ever been charged, well, then all bets are off. You have to disclose it.
And as we learnt in the first poll, these driving offences are very common. There's lots of people who have been in that situation. All right. So that's, I guess, the end of what we wanted to talk about with the case study and our questions. Does anyone else from the panel have any comments about the issues we've discussed so far to add before we go to our questions from the audience?
There's perhaps one last thing I wanted to add, and that is that many people come to court with their own calculations on speeding and what they believe the speed was at the time. Where the offence relates to a speeding camera, that type of device, which is a calibrated device, where there are regulations in the road transport legislation that require regular oversight. It's not a matter of simply turning up and saying, well, look, it says I was doing 102 kilometres per hour, but if you look at my GPS and my navigator, and if you work out mathematically that I was here at 11:32 p.m, but I was there at 11:38 p.m, I couldn't have been going that fast. It doesn't work that way. In order to contest a fine on the basis that the device was not operating properly, for example, you need to call expert evidence, and there is a provision in the road transport legislation that says just that.
Yeah. And that might, I don't know if this question is related to that or if the panel can answer this, but we've had a question about, I guess, the lack of clarity about speed limits that change regularly sometimes through towns when speed limits change. Is that that's just how it is and it's strict liability, or does anyone have any comment about that, whether anything's being done about that?
That's how it is. You might be driving through a particular area where it's 110 kilometres per hour. It very quickly is then signposted 80, then 60, and as you drive through the township, it's 50. But then as you drive out of the township, it goes back to 80 and 110 again.
Yeah. And we had a question before the webinar as well about how to plead guilty to an offence of driving more than 45 kilometres an hour over the limit. I think that was on a racetrack was the question, but I guess that's also just depends if that's a public road, and that's one of those serious offence categories, I think. So I think we've answered how to plead guilty and what the process might be for that if you go to court.
Yes.
And I would just encourage that person that if it's a penalty notice that they've received, that they get some legal advice, because, you know, we've talked about the broad context of people's options, but every person's circumstances will be different, and it may be that a particular option is more appropriate for him or for them. So I would encourage them to get some legal advice about that if they've not yet taken steps to select any of the options that they have available to them.
Great, thanks, Tegan. All right. No, thanks, Your Honour. That was a very relevant extra thing to add, I think. We've got a few questions coming in from the audience now, which is great. So we might just go through those. So at the end, I'm going to show you a list of links and resources, and you will get those links in an email after the webinar. So we did have some questions about more specific driving things, about U-turns and merging, and there's one about are you allowed to eat food and drink while driving? Obviously not drink alcohol, but are you allowed to eat and drink while driving? If that's something we can answer. Otherwise, you're going to get a link to the road rules. So you will be able to look up all these things yourself. Did anyone have any cases about eating and drinking? Maybe, Your Honour, this is a good time to talk about the a recent case that was in the media about a mobile phone that what might have been more like an eating issue.
Yeah, many of you may have seen a report that came through one of the newspapers over the weekend about a matter that was dealt with here at the Downing Centre by one of our magistrates, a very experienced magistrate. That involved someone contesting a camera detected mobile phone offence. These types of technologies are way beyond me, but what they do is they take a photo of someone who appears to be holding a mobile phone. The algorithm works a certain way, and then there's the human element. A person will look at the photo and decide whether an infringement should be issued. On this occasion, an infringement was issued. The person elected to have it heard in court and said that, in fact, it was not a mobile phone. It was one of those snack or dipper type cheese and cracker packets. Her Honour had to decide not whether it was a dipper packet or a cracker packet. She had to decide what we do every single day. That is, whether she can be satisfied beyond reasonable doubt that this was a mobile phone. The onus of proving any criminal offence in New South Wales is one which rests with the prosecution. It is the prosecution who must prove whether a defendant is guilty beyond reasonable doubt. That requires the prosecution to prove each and every element of that offence. That is, that the person was driving. That is, that the person was holding a mobile phone. If the magistrate is left with a doubt, a reasonable doubt, not a fanciful doubt, but a reasonable doubt that it might not be a mobile phone, then the appropriate verdict is one of not guilty.
Thanks. So eating the snack packet while driving is not illegal?
Well, in this case, it wasn't, because he had his hand partly on the steering wheel, and so you still need to have control.
Okay.
Of the vehicle. I suppose if he was using his knee to drive, or if someone was using their knee to drive while eating and putting makeup on, the result might have been different.
All right, we've got a few more questions. I think we've got a couple of minutes. So Tegan, maybe this is for you. What are the effects of having a license suspension record in maybe future career or in your everyday life?
I suppose it might depend on the reason for their license suspension. It may be that they have traffic matters on their record that meant that they accrued demerit points and therefore were suspended. This may not be something that ended up on their criminal record because they'd never attended court for these matters. And as His Honour was saying earlier, it's a matter of what is required to be disclosed to, or to their lawyers or to whoever it is that they are questioning whether that needs to be reported. Or it may be that, in fact, their licence was disqualified, which is the court's power to stop somebody from driving for a particular period of time. And if that person was disqualified, it would generally mean that that person's been convicted, which means it would be on their criminal record. So it just depends on how that person came to lose their license, whether that was by the courts, whether that was by the demerit point system that Transport New South Wales looks after, and what the disclosure requirements are, depending on who they're disclosing that to.
Thanks, Tegan. And I'm just going to ask one other question. I think, Your Honour, this is about what you were talking about, personal circumstances. If you can answer this, what do you consider if someone has been exposed to domestic violence before an offence, would that be like a mitigating factor in a speeding fine, for example?
Let's say for a moment someone was fleeing an incident, a domestic violence related incident, and as he or she was fleeing that incident, leaving their home, they went through the stop sign. Then by all means, it is something relevant to take into account. Of course, it would need to be backed up by something it doesn't necessarily need to be backed up by documentary evidence all the time. I might hear some evidence from the defendant, and I might accept that defendant as being a credible and truthful witness, at least in relation to that point. Alternatively, it might be backed up by something else, by an AVO having been taken out an hour later. It might have been backed up by police attending the premises. There needs to be evidence on which to rely to ground the submission that one's personal circumstances ought to be taken into account, so as to result in a more tempered sentence, a more lenient sentence.
Thank you. I might put up on the slide now where you can go for help, because we've had a few more questions about specific issues around driving and parking. So, and you will get these links in an email tomorrow. So if you have specific questions, the people who've asked us questions about their situations, what we suggest is you have a look at these websites. So Law Access New South Wales has information on their website, including sort of guided pathways. So that's sort of, which leads to like particular information for your situation. So do have a look at Law Access. Legal Aid New South Wales has fact sheets about driving. Somebody also asked about, can you access the road user handbook? So it is available online. So we will give you the link. It's in a few community languages as well. So that should be helpful for people who've got those specific questions about their driving or parking matters. Finally, I'll just quickly show you what we've got coming up. So the webinars we've got tomorrow on employment and the law, focusing on discrimination and sexual harassment in the workplace. And on Friday, we've got debt and the law. So what can you do about things like, utility bills, credit cards, mortgage debt. So that's what we've got coming up, and we're right on time. So I will now have to say thank you to everyone for joining us today, and especially thank you to our fantastic panelists. So thank you everyone for joining us today. You will get a survey that pops up when this webinar ends, and we'd really love your feedback about this webinar. As I said, the recording will be on our Legal Aid YouTube channel. So if you'd like to go back and watch it again or share it with your friends, that would be great. So thank you to Your Honour, Tegan and Kirsty. We really appreciate your time today. I'm sure everyone in the audience appreciates your time too. And we've got some thank yous coming through in the Q&A. So have a great Law Week, everyone. Thank you.
Thank you.
Thank you.
Thanks, everyone.